Rights and Environment, International Perspective is the second chapter we will be dealing. International human rights exist to a clean environment. There are, of course, a range of general human rights provisions that may have relevance in the field of environmental protection, such as the right to life, right to an adequate standard of living, right to health, right to food. The preamble to the seminal Stockholm Declaration of the United Nations Conference on the Human Environment 1972 noted that the environment was essential to the enjoyment of basic human rights, even the right to life itself. While Principle 1 of United Nations Conference on the Human Environment 1972 stated that man has the fundamental right to freedom, equality and adequate conditions of life in an environment of equality that permits a life of dignity and well-being. Article 24 of the African Charter of Human and People Rights 1981 provided that all people shall have the right to a generally satisfactory environment favorable to their development, while Article 11 of the Additional Protocol to the American Convention on Human Rights 1988 declared that everyone have the right to live in a healthy environment and that the state parties shall promote the protection, preservation and improvement of the environment. The reference to human rights in the Rio Declaration on Environment and Development adopted at the United Nations Conference on Environment and Development in 1992 are worth mentioning. Principle 1 declares that human beings are at the center of concerns for sustainable development. They are entitled to a healthy and productive life in harmony with nature. In 1994, the final report on human rights and the environment was delivered to the United Nations Subcommission on Prevention of Discrimination and Protection of Minorities. The report contains a set of draft principles on human rights and the environment, which includes the notion that human rights, an ecologically sound environment, sustainable development and peace are interdependent and indivisible, and that all persons have the right to a secure, healthy and ecologically sound environment. This right and other human rights, including civil, cultural, economic, political and social rights, are universal, independent and indivisible. The Stockholm Declaration of the United Nations Conference on the Human Environment 1972 emphasized in Principle 8 that economic and social development is essential for ensuring a favorable living and working environment for man and for creating conditions on earth that are necessary for the improvement of the quality of life. While the sovereign states have the right to exploit their own resources was also stressed. Principle 2 of the Rio Declaration adopted at the United Nations Conference on Environment and Development 1992 noted that states have the sovereign right to exploit their own resources pursuant to their own environmental and developmental policies, while Principle 3 stated that the right to development must be fulfilled so as to equitably meet developmental and environmental needs of present and future generations. The next chapter is the Rio Declaration on Environment and Development 1992. Out of the Earth Summit in 1992, 3 documents emerged, one of which was the Rio Declaration on Environment and Development. In Principle 22, Declaration states that indigenous people and their communities and other local communities have a vital role in environmental management and development because of their knowledge and traditional practices. States should recognize and duly support their identity, culture and interest and enable their effective participation in the achievement of sustainable development. The same principle is echoed in the Biodiversity Convention in Article 89. The right to a healthy environment is now to be found in a number of regional human rights instruments around the world. Article 11 of the Additional Protocol to the Inter-American Convention on Human Rights, 1994, popularly known as the San Salvador Protocol, states that everyone shall have the right to live in a healthy environment and to have access to basic public services. The state party shall promote the protection, preservation and improvement of the environment. The Convention on the Rights of the Child 1989 at Article 24, Clause 2, Clause C requires state parties in the matter of combating disease and malnutrition to take into consideration the damage and risks of environmental pollution. The African Charter on Human and People's Rights 1981 proclaims in Article 24, Clause 1 a right to a general satisfactory environment favorable to their development. In fact, the final report of the Special Rapporteur on Prevention of Discrimination and Protection of Minorities listed over 15 rights relative to environmental quality. Some of these include the right to freedom from pollution, environmental degradation and activities which threaten life, health or livelihood. Protection and preservation of the air, soil, water, flora and fauna. Healthy food and water, a safe and healthy working environment. In the mid-1990s, recognizing the urgent need and importance of deepening the link between human rights and environment and of exploring ways to achieve a better collaboration, harmony and complement the agendas of different United Nations institutions working on both subjects, the United Nations created the special position of a Special Rapporteur on Human Rights and Environment. The Rapporteur prepared an important report, the Centenary Report, which offered a theoretical, thematic and practical framework to address the linkages between human rights and the environment protection. Now we will deal with the judicial activism in the area of human rights and environment. If we look at the developments that are taking place through the intervention of national courts in various parts of the world, we come to note that the courts are moving the right to a healthy environment up the hierarchy of human rights by recognizing it as a fundamental right through landmark decisions. In Argentina, the national constitution recognizes since 1994 the right to a healthy and suitable environment. In Colombia, the right to the environment was incorporated in 1991. In the case of Antonio Mauricio Monroy Cespedes, in 1993, the court observed that side by side with fundamental rights such as liberty, equality and necessary conditions for people's life, there is the right to environment. The right to a healthy environment cannot be separated from the right to life and health of human beings. Now let us know about the contribution of the Supreme Court of India. The Constitution 42nd Amendment Act 1976 explicitly incorporated environmental protection and improvement as part of state policy through the insertion of Article 48A. Article 51A, Clause G imposed a similar responsibility on every citizen to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for all living creatures. Rural Litigation and Entitlement Kendra versus State of UP was one of the earliest cases where the Supreme Court dealt with issues relating to environment and ecological balance. The expanded concept of the right to life under the Indian Constitution was further elaborated on in Francis Coralie Millen versus Union Territory of Delhi, where the Supreme Court set out a list of positive obligations on the state as part of its duty correlative to the right to life. The importance of this case lies in the willingness of the part of the court to be assertive in adopting an expanded understanding of human rights. The link between environmental quality and the right to life was further addressed by a constitution bench of the Supreme Court in the Charan Lal Sahu case. Similarly, in Subhash Kumar case, the court observed that right to life guaranteed by Article 21 includes the right of enjoyment of pollution-free water and air for full enjoyment of life. Through this case, the court recognized the right to a wholesome environment as part of the fundamental right to life. The Supreme Court has used the right to life as a basis for emphasizing the need to take drastic steps to combat air and water pollution. It has directed the closure or relocation of industries and ordered that evacuated land be used for the needs of the community. The courts have taken a serious view of unscientific, uncontrolled quarrying and mining, issued orders for the maintenance of ecology around coastal areas, shifting of hazardous and heavy industries, and in restraining tanneries from discharging effluents. Another expansion of the right to life is the right to livelihood, Article 41, which is a directive principle of the state policy. Another important concept is the sustainable development and human rights. The concept of sustainable development originated with the report of the World Commission on Environment and Development. Our Common Future, the Brundtland Report of 1987, which defined sustainable development as development that meets the needs of the present generation without compromising the ability of future generations to meet their own needs. Conceptually, sustainable development can be conceived of as integrating three pillars: international environmental law, international human rights law, and international economic law. Principle 1 of the Rio Declaration of the United Nations Conference on Environment and Development employed language of human rights law, the second pillar of sustainable development. The concept of sustainable development contains three basic components or principles. First among these is the precautionary principle, whereby the state must anticipate, prevent and attack the cause of environmental degradation. The Supreme Court has accepted the principle and applied it on several occasions. In the Taj Trapezium case, applying the precautionary approach, the Supreme Court ordered a number of industries in the area surrounding the Taj Mahal to relocate to introduce pollution abatement measures in order to protect the Taj from deterioration and damage. The second component of the doctrine of sustainable development is the principle of polluter pays. The principle states that the polluter not only has an obligation to make good the loss, but shall bear the cost of rehabilitating the environment to its original state. The Brundtland Commission defined sustainable development as development which meets the needs of the present without compromising the ability of the future generations to meet their own needs. Another important aspect of the right to life is the application of public trust doctrine to protect and preserve public land. This doctrine serves two purposes. It mandates affirmative state action for effective management of resources and empowers the citizens to question ineffective management of natural resources. Public trust is being increasingly related to sustainable development, the precautionary principle and biodiversity protection. Moreover, not only can it be used to protect the public from poor application of planning law or environmental impact assessment, it also has an intergenerational dimension. In MC Mehta versus Kamalnath and others, the court added that it would be equally appropriate in controversies involving air pollution, the dissemination of pesticides, the location of rights of ways for utilities and strip mining of wetland, filling on private lands in a state where governmental permits are required. In both MI Builders Private Limited and the Majra Singh, the court reconfirmed that the public trust doctrine has grown from Article 21 of the Constitution and has become part of the Indian legal thought process for quite a long time. Now let us know how the corporations act as vehicles for social development. The mandate from the United Nations World Summit on Social Development, Copenhagen, the World Summit on Social Development at Copenhagen in the year 1995 marked a paradigm shift from development through aid to development through trade and investment. This meant that part of the task for the state in providing an enabling environment for social development was to provide an environment in which NGOs and civil society organizations would function autonomously and effectively and act as a check on corporate excesses. Part of the task of the state as well was to provide a level playing field in which all corporate actors would be made to strictly comply with international and national standards relating to human rights, workers' rights and the environment. Now the very important climate change and the concept of human rights. The OHCHR published its report on climate change and human rights in January 2009. After receiving submissions from states, international agencies and non-governmental organizations. In preparing the report, the OHCHR faced two legal questions. Does climate change violate human rights law? And what obligations, if any, does human rights law impose on states with respect to climate change? In response to the first question, the OHCHR report states that climate change has and will have a range of effects on human rights. International human rights law complements the United Nations Framework Convention on Climate Change by underlining that international cooperation is not only expedient but also a human rights obligation, and that its central objective is the realization of human rights. I would like to say that the violations of human rights continue to take place on a large scale in most of the countries of the world, including in the field of environment. The combination of human rights and environmental obligations provide a powerful tool in preserving and protecting the human environment and also playing a pivotal role in national and international environment protection efforts. The link between environmental issues and human rights is laudable. International and national environmental human rights laws must safeguard the right to life. To safeguard the legal right under the new human right to environmental protection, it is necessary that it should be implemented through the international and national machinery. Human rights are fundamental to human nature, without which people cannot live as human beings. All human rights and environment are interdependent. Right to an adequate environment is a human right because human species cannot exist in this planet without an adequate environment. Hence, it is need of the hour to propagate environment protection as human right. Human rights and fundamental freedoms help us to develop our intrinsic qualities, intelligence, talents and conscience to meet our material and spiritual needs. Hence, it is the need of the hour to propagate environmental protection as human right. The judicial activism played by the courts is laudable in protecting the environment from the human rights perspective, particularly in the Indian context. Dear students, I hope you have enjoyed this session. The next session, I will be dealing with the public interest litigation and judicial activism. Thank you.